All right.
On the record.
I need everyone to, thank you. Court is calling 2025 CR 011020, 2025 CR 011311C, 2025 CR 011309A, State versus Adrian Isaac Hernandez. Can I have parties announced for the record?
Melissa Christian for the defendant.
And are you Adrian Isaac Hernandez?
Yes, ma'am.
Counsel, in each of the cause numbers, have you received all discovery and did you review it with your client?
I have, and I have done so, yes.
And each cause number, the court will find that the state is in compliance with discovery. Mr. Hernandez, in each cause number, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
All right, pause here. This is the court officially confirming that all discovery has been handed over and reviewed. Translation: the defense can't later claim they were blindsided. This is the judge locking the door on future excuses. Do you think defendants truly understand everything they're agreeing to at this stage, or are they just nodding along?
Yes, ma'am.
And each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
State, in the cause number ending in 20, are you proceeding on the indictment as presented?
Yes.
And the cause number ending in the letter C, are you proceeding on the indictment as presented?
Yes.
And the cause number ending in the letter A, are you proceeding on the indictment as presented?
Yes.
Mr. Hernandez, in each of the cause numbers, did you review the documents entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
And the cause number ending in 20, you're charged with collision involving an injury. The range of punishment is not more than 5 years in the prison or up to 1 year in the Bexar County Jail, and a fine not to exceed $5,000. And the cause number ending in the letter C, you're charged with aggravated robbery. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine.
Now listen closely. Aggravated robbery isn't just serious, it's life-altering. 5 to 99 years, or life. That range is massive, and it gives the judge enormous power later on. Imagine hearing that and still moving forward. Would you gamble with a sentence that high?
And the cause number ending in A, you're charged with aggravated robbery. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
And each cause number, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
This part right here is critical. Deferred adjudication sounds like a break, but it's actually a razor-thin tightrope. One violation, one mistake, and the judge can drop the maximum sentence like a hammer. Is deferred adjudication a second chance, or just delayed punishment?
Yes, ma'am.
In the cause number ending in 20, if the court were to grant your application for deferred adjudication, you could, and if for any reason your deferred adjudication were revoked, you could be sentenced up to 5 years in the prison. In the other cause numbers for the aggravated robbery cases, if the court grants your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court will be able to sentence you up to life in prison and up to a $10,000 fine. Did you understand? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Here's the bombshell: a 12-year prison cap, deadly weapon finding, and the state is opposed to deferred adjudication. That tells you prosecutors believe this defendant is too risky for leniency. Everything running concurrently may sound good, but prison is still prison. Does this feel like a deal or damage control?
I do believe.
Mr. Hernandez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In the cause numbers ending in C and A, according to your plea bargain agreement, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. The state is opposed to your application for deferred adjudication. All of these cases will run concurrently, including the motion to revoke, and the state will take in consideration 2025 CR 011310C and 2025 CC 009777. And the cause number ending in 20, according to your plea, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine. State is opposed to your application for deferred adjudication. All of the cases will run concurrently, and the same cases will be taken in consideration that were previously stated. Did you understand that to be your plea bargain agreement in each of these cause numbers?
Yes, ma'am.
State?
Yes.
Defense?
Yes, Judge.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
There have been motions filed, but nothing that would qualify.
All right, then in cause number 2025 CR 011020, how do you plead?
No comment.
This is where things get tense. The court says there's enough evidence to find him guilty, but holds off. Why? Because now everything rides on what happens next. January 26th becomes Judgment Day. Witnesses. Evidence. Consequences. If you were the judge, would you already have your mind made up?
And cause number 2025 CR 011309A, how do you plead?
No contact.
And cause number 2025 CR 011311C, how do you plead?
No contact.
State any evidence to support the defendants, please.
The state states wanted attachments in each.
And we have no objection in each case.
All right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. In each cause number, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We'll be back on January 26th. At that time, the court will make a decision based upon your applications based upon any evidence that is submitted. Counsel, is there a need for a mental health evaluation or no?
I don't believe so, Judge. We will have live witnesses on the 26th.
All right, thank you.
Thank you, Judge. May we be excused?
Thank you. Have a good
Yes,
day.
you too. So today is set for a contested.
So, this, I just wanted to make sure for the council.
Yes.
Please. So, Judge, in talking with the witnesses, yes, mind you, this is a first setting. So we had a bond hearing previously that was
Yes.
separately contested. So, in talking with the CSO and then witnesses that are part of the allegations currently on the MTR, it sounds like there is another incident that could substantively affect the allegations on the MTR, potentially other cases that I have not been able to flush out yet. This is information we received about 3 days ago. So, courtesy of defense, I'll let you know. I'm trying to see if there's any law enforcement response and police reports associated with that. Judge.
And here comes the chaos, defense attorneys trying to withdraw. That doesn't happen lightly. When lawyers step back, it usually signals breakdowns, conflicts, or something seriously off the rails. Ever notice how cases unravel right before the biggest decisions are made?
But we'd ask for a little bit of time to get that information.
Obviously, if we were to go forward with it, we want the court to hear everything. It makes no logic to file a new MTR down the road if there's new allegations. But also, we have filed a motion to withdraw based on Mr. De Leon has had an inability to.
All right, do you have the motion?
I have a copy. It's been e-filed, Your Honor, but
All right, are you aware that your attorneys wish to withdraw?
Well, they told me that right now. We were talking, and I wasn't aware that this was going to keep moving forward. That they were continuing to withdraw. We were talking right now, and so I mean, can we talk? Or?
no, Judge, I think the allegations keep growing and the obligation is not. So I think, in fairness to Mr. De Leon, if he is
Now,
going to.
here's my question. All right, they filed a motion to withdraw. Here's the thing, in this court, I like to take things in an orderly fashion. Before I even address this reset, I want you to speak to your attorneys about the motion to withdraw, and they will explain to you why they're seeking to withdraw.
Okay.
Either you agree to their withdrawal or not. If you don't agree to their withdrawal, I'll still have a hearing on the motion to withdraw today.
Okay.
Because if I were to grant it, I don't want you to be in limbo with no attorney.
Okay.
All right? So if y'all have a seat and just let me know quickly because we're going to recess this morning docket shortly.
Yes, ma'am.
All right, thank you.
And Judge Mary is calling me down at 1:45.
No, go to Judge Mary, and actually, if you could let me know,
Yes, ma'am.
what date do you anticipate having everything?
I would hope to have some information the next week or two, Judge, but I guess practically. with where we
I
are.
mean, the contested hearing then will be set in the new year because,
I would think so, Your Honor.
yes. So, no, I haven't ruled on your motion yet, but if you can confer with Norma,
Yes, ma'am.
just to have a date for you in case I grant their motion to withdraw. So if you'll just confer with her before you leave, and then I can take this up without your presence, because it appears that if he stays on, he's going to want a new date for the contested, and if there's an attorney that's appointed to him, they're going to need a new date as well.
Yes, ma'am. So I'll give Ms. Norma a tentative date, and then if there is a new attorney, if
They'll have that
if that
date.
doesn't work for them, then we can confer some more.
Okay, all right, awesome, thank you.
Judge.
Yes. So can I have your motion to withdraw?
Yes, ma'am.
Are you still seeking to withdraw?
Yes, ma'am.
All right, court is calling 2024 CR 3774 State versus Luis Alberto De Leon Jr. Can I have parties announced? Just for the defense, please.
Jay Norton and Patrick Valentine.
And are you Mr. De Leon? All right. State's attorney was present, but was called to a different court. The state informed the court they had no opinion on your motion to withdraw. Have you had a chance to discuss the motion to withdraw with your attorneys? Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Luis De Leon.
All right, your counsel has filed a motion to withdraw. They state there's an issue with your contractual obligations. Are you aware of those issues?
Yes, ma'am.
All right, do you have any objections to their motion to withdraw?
No.
All right, the motion to withdraw will be granted.
And Judge, while Mr. De Leon is here, Mr. Bunk asked me if I would text him and ask him, inform him if the court granted our motion. I will do that so they can come back and so we will tender information that we have to Mr. Bunk.
All right, so Attorney Bunk will be your attorney. This case is going to be recalled for January 12th for a contested hearing. This attorney will share any discovery information, police reports, whatever he has received with Mr. Bunk, so that Mr. Bunk will be able to represent you.
Yes, ma'am.
Do you have any questions about anything?
No, ma'am.
All right, thank you.
Good luck.